Well, thank you so much to Sean O'Brien and the rest of the Memphis Law Review staff for allowing me the chance to be even just a tiny part of such a vital conversation. For those of you whom I haven't had the pleasure of meeting yet, my name is John Newman. I'm a professor here at the law school. My area of expertise is antitrust law, which focuses on consumer market protection, basically. But the most important marketplace, of course, and the one that we in the antitrust world have nothing to say about, is the marketplace for ideas. So I'm so pleased to be a part of this conversation, to get to experience all these wonderful speakers. Judge Lynn Adelman, in particular, I'm excited to introduce. He is currently a U.S. District Judge. He's presiding in the Eastern District of Wisconsin. After graduating from Princeton University and Columbia Law School, Judge Adelman practiced with both the Legal Aid Society of Wisconsin and in private practice. He also served as a member of the Wisconsin State Senate for 2 decades until his appointment to the federal judiciary in 1997, so a wealth of experience. During his time on the federal bench, Judge Adelman has presided over a number of noteworthy cases. Of course, just one example is Frank et al. V. Walker, which is a 2014 decision in which Judge Adelman ruled that a Wisconsin voter identification law was a violation of Voting Rights Act Section 2, the one we still have apparently, and the U.S. Constitution. Even more recently, though, he published an article entitled "How Big Money Ruined Public Life in Wisconsin." This was the lead article in volume 66 of the Cleveland State Law Review. I won't spoil it. It's available online, but I will just say that it is absolutely a must-read for anyone who cares about the influence of special interests on politics in our country today. So with that, I hope you'll join me in welcoming the Honorable Judge Lynn Adelman.
Thank you very much. I thank the University of Memphis Law School for inviting me. I've enjoyed some of these really exciting presentations. I'm going to talk, I guess, about redistricting and a specific aspect of redistricting. It's a controversial subject. Mostly what's controversial about redistricting is the gerrymander, and where one party basically can disenfranchise a lot of voters in a state and basically make them unable to seriously participate in politics in a state. And there's some Supreme Court cases. I think next week there's going to be the Supreme Court's going to hear a case on racial gerrymandering. And then a couple of weeks from now, I think they're going to hear some cases on partisan gerrymandering, which is a really hot issue. Last term in the U.S. Supreme Court, there was a Wisconsin case. I'm from Wisconsin, and there was a Wisconsin case, Gill versus Whitford, that really addressed the issue of partisan gerrymandering. And sadly, the United States Supreme Court basically ducked the merits of the issue, decided it on standing, remanded it back to the district court, and that's where it's pending presently. But the part I want to talk about today is not so much the gerrymander, but another aspect of redistricting, which I think hasn't really gotten much attention. The way I got into it is I was in the state Senate in Wisconsin for 20 years before I went on the bench, and I was a Democrat, and I represented a pretty Republican district. Mostly it was about a 54% Republican district. So every redistricting was really very traumatic for me, because all they had to do was jiggle the lines a little bit, and that would have been the end of me. And I got in the first time, I got a good break. My opponent got convicted of a felony 10 days before the election. Today that might not make any difference, but it was a problem then. I was in the legislature during 2 redistrictings, and the redistrictings, Wisconsin is a very purple state. All the time I was there, we're sort of going back to that a little bit, But the legislature, at least one house of the legislature, was of a different party than the governor. So all the time I was there, there never could be an agreed redistricting plan between the houses, because the house, the party that was in the minority, mostly when I was there, the Republicans were in the minority, and they wanted to be in the majority. And the Democrats, of course, they're in the majority. They're not going to negotiate themselves into the minority. So basically, the minority party always said, well, let's just roll the dice. So all the times I was in there, the redistricting was done by a 3-judge federal court. It was 1982, 1992. And then I got on the bench in 97, but in 2002, again, same thing happened. So we had 3 redistrictings in Wisconsin done by federal judges, and they were all really unfair, every single one of them. Not because the federal judges were gerrymandering anything. They wanted to be neutral. They didn't want to, they were behaving appropriately. In one case, the first case, I think that the federal judge wanted to just completely, I say one judge, in each case I think one of the 3 federal judges sort of dominated the redistricting, so I might refer to it that way. In the first case, the federal judge wanted to keep politics completely out of it. So he wasn't going to consider any political factors at all. He was just going to draw lines based on, I don't know exactly what, how they looked, aesthetics maybe. He wasn't going to consider politics. And of course you can't draw a map that isn't political. All maps have a political impact, and the map that this judge drew did also. And that that map actually, maybe I'll mention that in a minute. That sort of had a really terrible effect on me personally. It basically would have eliminated my seat. The 1992 map, the judges wanted to be fair. They understood what a politically charged issue and how important redistricting was politically. And of course, the reason it's important, the reason there's so much time and energy and effort spent on redistricting is because it is political. But yet, it's sort of an irony that the law of redistricting basically doesn't consider politics. And so the redistrictings in 1992 and 2002, the judges understood how important it was politically, and they wanted to be fair, but they didn't know how to go about it. In 1992, the way the judges went about drawing fair lines was they took the Democratic plan for rural Wisconsin and the Republican plan for southeastern Wisconsin, and they thought, well, this is going to somehow even out. Well, it didn't actually do that. So I guess what I'm saying is that even though you don't have a gerrymander, you can have a very unfair redistricting that basically has the effect of disenfranchising members of one political party. I would argue, actually, that the 3 redistrictings in Wisconsin that were done by federal courts all really had the cumulative effect of disadvantaging the Democrats in Wisconsin and created the basis for the takeover of the state by the Republicans, and in 2010, that created this gerrymander that went to the U.S. Supreme Court last term. So, I mean, I would argue that somewhat indirectly and unintentionally, the redistricting done by federal courts led to this pretty terrible gerrymander that's still pending. I'll give you an example of the first one, the 1982 redistricting, which was this one I mentioned. My district was about 54% top of the ticket Republican. So it was always a struggle. And the way the judge drew the lines in that district, in that redistricting, was to make it about 58% Republican. So really that was just more, that was just more that you can be the best candidate in the world and really work hard and do everything right, but when you get to a certain number, you can't overcome it. And that's sort of what happened. But it's sort of actually, it's not a bad story. I had a 4-year term. Wisconsin senators, you get a 4-year term. And so the judges drew the map in 1982, and right after he drew the map, they had a new election, and they wound up still with he basically, the way he drew the map, he basically switched what was a pretty Democratic legislature into essentially what became a Republican legislature. But he did it so late, it was so late that the redistricting happened that the Republicans really didn't have any time to recruit candidates. And so most of the Democratic incumbents still won, even though that the judge had sort of he basically unintentionally gerrymandered the state by not thinking about politics at all. Okay, they ran the elections, and a Republican governor who had vetoed the Democratic plan and caused the case to go to court in the first place was replaced by Democrats. So the Democrats had, after the election, they had the governorship in both houses of the legislature. And what they did then was they didn't like the plan that the federal court had come up with, so they did their own plan. And they did a new plan, and it was not a gerrymander. It was actually a very fair plan. They did not make any real effort to try to disenfranchise anybody, and it respected all the rules of redistricting, compactness, contiguity, one person, one vote, protection of minorities. I mean, it was really quite a good plan. The one thing that was pretty interesting about it was that because there had been an intervening election between the judge plan and the legislative plan, some people in the state, maybe about 10,000, a really small number of people in the state, did not get to vote for senator every 4 years because of the way the switching around. Senator's a 4-year term, and some people had to wait 6 years to vote for senator because of the way some people were shifted around. So the Republicans, of course, did not like the plan, the legislative plan, and they went back to the same federal court and said, basically, they said, we like your plan better. This Democratic plan is unconstitutional, and they made a bunch of arguments. And the court actually bought this argument that the Democratic legislative plan was unconstitutional because it had not let certain people vote for state senate for 6 years instead of 4 years. And now this is the plan, of course, that I'm basically getting. I'm not up for election until 1984, so I'm getting ready to retire because I'm not going to be able to win in this 58% Republican district. Because I had only started a few years earlier, it was going to be a relatively short political career. Anyway, that's what they did. The judges threw out the legislative plan, and the Attorney General of Wisconsin, then representing the state, representing the legislature, takes an appeal to the U.S. Supreme Court. And redistricting cases, first of all, they're one of the few kinds of cases, maybe the only one, that you get a 3-judge bench automatically, not a 1-judge bench. That's one thing. And then the second thing is that appeals from redistricting cases go directly to the U.S. Supreme Court. They don't go to a court of appeals. And that's another thing that's unique about it. So my sort of thought was, well, the Supreme Court's not going to intervene in this matter at all because, they're just not. It's pretty unlikely that they're going to do that. So actually the matter went to Justice Stevens, who is the circuit court. This is in the 7th Circuit Court of Appeals, and he was each Supreme Court judge is sort of assigned to a circuit to sort of preside over matters in that circuit. So the case went to Justice Stevens, and he basically said that this theory that the federal judges had used to throw out the duly enacted legislative redistricting plan was sort of cockamamie. This idea that, you know, that 10,000 people didn't get to vote for state senator for 6 years instead of 4 years, that was really pretty lame theory. And he took it to the whole court, and they agreed, so that they did a 3-line order. Basically, the U.S. Supreme Court did a 3-line order, essentially vacating the 3-judge bench plan and approving the legislative plan. Of course, that put me back into the district that I was in before, and the very strong candidate who was getting to run against, who was going to run against me in the new district, dropped out. And, you know, so that sort of saved my political career. It was sort of interesting. Justice Stevens used to come to the Seventh Circuit Convention every year, you know, I always used to thank him for saving my political career. But anyway, the point of this is not to just tell war stories. I guess what I'm saying here is that there should be some political fairness standard that should govern all redistrictings. Not all, you know, they have independent commissions in some states, like Iowa. They have an independent commission to do redistricting. And in other states now, because of rebellion against gerrymandering and manipulation by legislatures, totally justified rebellion, other states are now considering, and there's referenda in states about creating independent commissions. And that's fine, I support that, except that there's one question, and that is, how do you decide whether an independent commission does a good plan or not? I mean, just because they're independent doesn't automatically mean they're going to do a good plan or a fair plan. What is a fair plan? I mean, that's sort of the question. So I got to thinking about this question and talking to some colleagues who were interested in it, and you know, to some extent, all my interest in this stemmed from my own personal experiences, which I've told you. And so we came up with sort of an idea on what is a fair plan, how to decide it. And our basic idea is that redistricting should reflect the will of the voters in that particular state. And so how do you find out what the will of the voters is in a given state? And our argument is like, well, you have to look at data. You have to look at numbers. And basically you have to look at past elections. So basically to sort of sum up, our idea is that you take 5 previous elections, and the best elections to take are gubernatorial or presidential elections, because you don't want elections where there's going to be some sort of very popular candidate or some particular specific idiosyncratic set of circumstances. You really want to get a kind of an idea of what is the partisan makeup of the state. So if you look at the last 5 presidential or gubernatorial elections and you average them, that'll tell you, I think pretty accurately, how Democratic or how Republican the state is. Wisconsin might be a 51% Democratic, 49% Republican. I don't know exactly. Maybe it's 51% Republican. Whatever it is, and you sort of make this. You figure out statistically what the partisan makeup of the state is, and that gives you your data. That tells you what the voters in the state prefer. And then after that, so then once you've figured that out, you've created a standard for how to do a redistricting in the state. Now there are other standards, of course. The federal standards are you have to have one person, one vote, as was just discussed. and you have to have protection of minorities, and then there's some state standards that the districts are supposed to be relatively compact and relatively contiguous. But I guess what I'm suggesting is that there should also be a fairness standard so that voters of one particular party are not disenfranchised. And so basically the standard is the percentage that these last 5 elections tell you. So, for example, if Wisconsin is a 51% Democratic state, then 51% of the legislative seats should at least lean Democratic. That doesn't mean they're going to automatically vote Democratic or vote Republican. I mean, obviously some of these districts are going to be only slightly Republican, slightly Democratic. But basically, if you have that sort of a criteria governing all elections, you can come up with a redistricting plan which really respects the will of the voters, and which there's not a lot of sort of, hey, this is the rule, this is what your standard is, this is how you decide the partisan makeup of a state. So that's the idea that we sort of came up with. I mean, you could do this by legislation, you could do this by, there's a lot of ways you could do it. An independent commission could just decide to do it on their own. They could just say, look, we think it's important to try to be politically fair to all voters in a given district, and so we're going to adopt this plan. I think that it respects the will of the voters, and it also avoids disenfranchising minorities. I mean, I think there's a lot of benefits that would come from this plan. What the Supreme Court has identified as the central evil of gerrymandering is the entrenchment of power in a political party that would be a minority party but for the gerrymander. And the most commonly cited examples of redistricting evils are cases where a party receives considerably less than 50% of the statewide vote, but nevertheless retains a minority of the seats in the legislature. Well, under the plan that we've proposed, that wouldn't happen. So it's a sort of a simple idea. I have not seen much discussion of it. I mean, all I've heard about redistricting is the problems of gerrymandering. And then everybody says, well, the way to get around gerrymandering is to have some non-political body do it, to have some non-political body that doesn't consider politics. But I don't think that's a very good idea. I mean, and that's why I go back to Wisconsin. We had three straight redistrictings done by federal courts, which are presumably neutral, not political, not interested in politics, just want to be a fair plan. And they didn't do a very good job because they didn't know how to do it. They didn't know what they were doing. I mean, right now you can get a lot of good data. You can redistrict. You can redistrict. I mean, that's the gerrymanders. People know how to gerrymander down to literally the block and the house. I mean, gerrymandering is so fine-tuned now. What I'm suggesting is you take the same tools and you use them not to gerrymander, you use them to create a plan that reflects the will of the voters. So anyway, it's an idea that it seems to me worth considering, and if anybody has any comments or questions, I'll be glad to answer them. Go ahead.
I'll defer to.
Okay.
Can you explain, sorry, thank you for that presentation. It's very interesting. Could you explain what you mean by there has to be politics in redistricting?
Well, redistricting is all about politics. I mean, why does anybody care about it? Because one party or another is going to get an advantage. So what I'm saying is that let's be open about that, and let's understand that that's an important factor, and let's let's decide based on what the political nature of the state is. Let's look at the political complexion of the state, what the voters want, and that'll govern what the political makeup of the legislature is.
But what you're asking for seems to me to have some element of proportional representation in the legislature, so that the legislature proportionally represents the makeup of the electorate of the state.
Right.
The Supreme Court has always rejected, rightly or wrongly.
Well, I don't know, have they rejected that? What do you mean?
I mean, just real quick, they said that it's not a right. He said that you're not entitled under the Constitution or under the Voting Rights Act to a minimum floor proportional representation. But to my knowledge, there's no authority that says
You can't do
cannot
it.
Try to do a partisan fairness proportional representation.
Yeah, I'm not saying that this is required by the Constitution. I'm just saying it's a desirable policy.
So to give an example, just this past fall in New Jersey,
Okay?
the legislature tried to do something similar to what you're talking about. They wanted to make a set number of the 40 legislative districts, quote unquote, competitive.
Okay.
And the way they define what competitiveness is they wanted to take all of the statewide elections and divide up how the voters voted. So the only statewide elections were for governor, president, and the 2 senatorial elections.
Okay.
And so they contacted a bunch of.
But as I recall, the New Jersey plan was sort of a underhanded gerrymander, wasn't it? I mean, it was sort of the way they sort of did it was going to be that the Republicans would never have a chance of winning a majority ever.
So the devil is in the details. So what they did
Right.
is they basically said whatever the election, however the state votes, a district that's like that is a competitive district. Well, it turns out the state over the last 10 years in all of those elections has voted 55% Democrat to population,
Right.
and 45% Republican.
Okay.
And so a district which would have 55% chance of electing a Democrat would be a competitive district, and they wanted 25% of the district to be like that. In a district that has 55% chance of electing a Democrat, plus or minus 5 points is what they allowed, would never elect a Republican.
Right.
So those quote-unquote competitive districts would all go Democratic.
Right.
Of course, the Republicans screamed, and all of these voting rights
Well-
groups got together. So
The problem in that was that they're saying we want X number of districts to be competitive. Now, I'm not saying that. I'm just saying, look, and there's always, like, under this plan that we're proposing, there's obviously going to be lots of fights about which individual districts are which way. I mean, this doesn't come close to solving any problems, but there's no rule about competitiveness in the plan we're talking about. And I think in the New Jersey plan, that's what caused the sort of underhanded gerrymander. No, it was the competitiveness rule. Yes.
And actually, I'm so glad that Professor Mazzo's question preceded mine. Because now that we got that out of the way, it's actually a useful dovetail to what I was going to ask, which is, I understand what I think I agree with your basic thesis. I understand that you're saying you don't want to try to create competitive districts. You want to try to create, there are 10 congressional districts in the plan, and it's a 60% Republican state. Then you should roughly try to have a plan that roughly 6 of the 10
Right.
would lean Republican, roughly 4 of the 10 would lean Democrat.
Right.
So my question is, if you do only that, and I think there's merit to it, is there not a tension though? Because you do want at least some competitive districts, do you not? You don't want all elections to be a foregone conclusion, because then the Republicans in the Democratic districts and the Democrats in the Republican districts basically throw up their hands and say it's a foregone conclusion. The only competition is in the primaries, and then we get extreme.
Well, I don't think by saying that you're going to have 6 out of 10 that lean one way or another, I don't think you can guarantee that those seats are going to wind up being safe seats for one party or the other, because I don't think you can, the people in the state aren't going to be divided that way. I mean, I think a lean Republican might be a 53 or 54%, which is still pretty competitive. I don't certainly want kind of entrenched people in any seats if you can avoid it.
Got it.
So, okay, thank you.